Good afternoon. This is Chris Wright again of PUBS Advisory Service. Today's podcast, I'm talking to Stuart Cakebread of Cerulean Law. Stuart has been a barrister dealing with landlord and tenant issues for, well, over 40 years, I believe, Stuart. Is that correct?
Regrettably so, yes.
Regrettably so. I first met Stuart just before the lockdowns, just before COVID, in that golden age where Britain, everything seemed sunny and uplit. And we got in contact over a mutual love of pubs. And in fact, Stuart, are you still a shareholder in a pub? Or is that
I certainly am. My partner is actually the chairman of the pub company
the chairman of the pub company?
in
Fantastic.
the
It's just the
village.
one pub, though, to be honest, isn't it? Yeah, it's just
At the moment, just one.
Just the one. Fine, fine. Unless all the villages merge together in Oxfordshire. But yeah, so you have an interest as a professional drinker and have a professional interest in your local pub, which is fantastic.
You could say that, yes.
Yeah, brilliant. So, Stuart, the reason I wanted to get you on a podcast was talk about an area which is highly contentious. It does require specialist advice. We've dealt with many of these cases, and it's the thorny issue of renewal of a lease, and that's under the Landlord and Tenant Act. And I've kind of scratched out a few notes myself that I think we'd like to cover today in this podcast. And I know we'll move at some speed, but towards the end we'll talk about a case study, a particular case that we know well, and that is
Sure.
caused problems for the tenant. I'm going to refer to everyone as tenants instead of lessees, but it's the
Fine.
catch-all. It's the
Yes.
catch-all. So kicking off with this, Section 30, Landlord and Tenant Act 1954, there are a series of notices that can be issued by the parties. Do you want to just give us an overview of these notices and when do they get issued?
Yeah. Let me just say something a little bit about the Act
Of
itself.
course, yeah.
This was a comprehensive Act passed in 1954, which applied at that stage to both commercial and residential tenancies and leases, but it now continues only in respect of commercial leases.
Fine.
And what it does is to provide protection for a commercial tenant um, against the termination of his lease and various other things. And so it's intended to provide stability for the tenant and the ability to continue his business and to avoid the possibility of a landlord granting a lease for a limited period of time and then getting it back and benefiting from the efforts of the tenant. So that's what's behind the act.
Excellent. Very admirable, and it's good to have that protection. So the notices, this is the thorny bit. People can issue notices, tenants can, landlords can. When does that happen
Yes.
when does that happen?
But let's start with let me just say again as background to that, that the overriding principle behind the act is that once you've granted a business lease, which is not contracted out, and we'll come to that a little later,
Yep.
it continues basically until somebody brings it to an end by a formal process.
Yes.
So, for example, you might have a lease for 5 years. You could still be there 7 or 8 years afterward the commencement, unless either party has decided to start the procedure to bring it to an end.
Yep.
So,
Excellent.
the underlying principle is a commercial lease continues until somebody brings it to an end
Ad infinitum,
ad
effectively.
infinitum.
Yes.
So, the notices. So basically, either the land once the contractual period has expired, so you've got a 5-year lease ends on the 1st of March, 2024. Um, Nothing can happen except by consent before that date. Then, but prior to it, either party can serve a notice indicating that they don't wish to continue with the tenancy.
Okay. Yep.
Um, or they can and they can do that after that date has passed if no one has done anything.
Sure.
And the tenant, what the tenant can do is serve a notice under Section 26 of the Act,
Yep.
which is basically a request to the landlord to grant him a new tenancy. It's as simple as that. And the landlord then has 2 months to say, I agree or I don't agree. If he does nothing, then he's deemed to have agreed.
Yep.
If he doesn't agree, then he's got to come back and set out one of the grounds which the Act provides for him being allowed to disagree and to object. Now, these vary. Um, some of them relate to arrears of rent, breaches of terms of the lease, and so on. He can say he's in arrears of rent. I don't wish to grant him new tenancy. And those are the non-compensatory grounds. In other words, it's the tenant's fault.
Yes, you are at
Landlord,
fault. Got you.
yeah.
Yeah.
And so the landlord's entitled to do it. And if ultimately proceedings go on and the court agrees with the landlord, tenant gets no compensation. He's brought it on himself, in essence.
Yeah.
But the ones I want to focus on are the discretionary grounds. And these are where the tenant is not at fault, but the landlord has a entitlement to seek to recover possession. And I particularly want to focus on the one that tends to arise in relation to the license trade,
Yeah.
which is section 31G. And that's the one that 95% of pub tenants face uh, as an objection.
Indeed.
The objection is based upon the landlord wishing himself to carry on his business on the premises.
Yeah.
So that's one way this can happen. The Section 26 notice is served within 2 months. Pub company landlord comes back and says, I want to use this for my own business. Uh, the other way it can happen is that the landlord serves a Section 25 notice, which basically is doing the same thing and
Mm.
saying, I object to the grant of a new tenancy.
Yeah.
And so either party can initiate the procedure.
And you cannot initiate this procedure any earlier than what date was this? Would
Um,
be.
I, 6 months before the end of the lease.
Fair enough. Yeah. So you have to grant, yes. Yeah.
No,
You have to
12 months. I'm sorry.
12 months, 12
Change that.
months.
12 months before
Yes.
the end of the lease.
Right.
Yes, and not later than 6 months, I think. Correct.
Fine. So you've got to get your skates on a bit if you're gonna issue that
Yes.
notice.
Yeah.
And these notices, they are formal, yeah. So your landlord's notice to you will be
Yes.
quite formal. It will be made by the
Yes.
solicitor in writing to your
Yes.
office address, etc., your business address. The tenant themselves, when they issue their notice, they're well advised to obviously follow exactly what it says in their agreement. They may
Yeah,
have
I
to
mean, I've
edit.
I've just recently been involved in one where a tenant decided to do it himself, made 3 attempts, all of which failed.
Yes, I think I had the record was six for a case I got involved with before it
Yeah.
was finally accepted. But
Yeah.
you're right, it is a little tricky and people do slip up. So the issuing of these notices is absolutely prescribed. It's written down in those
Yes,
agreements and there
absolutely.
are deadlines. So crucial that people get their
There
head
are
around that.
absolute
Absolutely.
deadlines. There is no discretion on the court to extend them, and they have to be in exactly the right form, or they fail.
Yeah, okay. And obviously you can have, as you said, multiple chances to issue it, but only up until the point the deadlines pass and then you could lose these
Correct.
rights. Yeah, sure.
That's correct.
So
And I should also say, sorry,
yeah,
importantly,
go for it.
when the landlord objects to the grant of a new tenancy, he has to exactly specify the ground.
Yeah,
So if it's 31G, he's got to say that. He can't then subsequently say, well, actually, I also plan to develop the property. Too late. It's got to be in that notice he serves, or he can not raise it thereafter.
that's right. And we refer to these grounds as A to G. There are only seven grounds, but your landlord could issue more than one grounds. One is a
Correct.
minimum, but they could do three or four. Yeah. So,
Correct. Now, quite often in our experience, um, the landlord will add on grounds A and C, alleging either breaches of covenant or failure to comply with regulations.
mm,
Um, and they're usually rubbish. They're make weights there to terrify the tenant. For example, they will allege breach of covenant through there being dilapidations, failure to maintain.
sure.
All of this stuff in 98% of cases goes away.
Fine. That's very, very apt to say that.
So
Yeah.
you don't, that doesn't generally happen, but they quite often put them in to make weight to terrify the tenant.
Absolutely. So section 25, as we said, that's the landlord's notice to the tenant. Section 26 is the other way around.
Correct.
And section 27, just covered that one. What's that one for?
No idea.
Fair enough. We'll edit this bit. That's the tenant's notice to end the lease and just say, I want out. That's
Yes.
the the 3 month rule, isn't it? They just say a one off, so
Yeah,
that's not a
sorry.
problem. No, that's fine. That's all right. I don't always remember. Again, I struggled to actually find a template for it, but I did find one in the end attached to an old annex of the Act itself. But there is one there. So suffice to say, we'll say, and Section
We
27.
don't get involved in those, I should hasten to
No,
add.
absolutely. Yeah. So Section 27 notices is where the tenant issues a notice to say, actually, I don't want to renew, I just want out. And they can issue that when there's 3 months left to go, or they have to give at least 3 months notice to the landlord in any event, and then they can leave. So that's the notices covered. Just touching upon tenants who can't issue these notices. So commercial tenants who are outside
Yeah,
of this protection. They're not outside of the whole act. Just cover that for me if you could, Stuart, a
yeah,
little bit. Yeah.
certainly. So the when the legislature passed this act, they wanted the default position to be you're protected by the act. You don't have to
Okay.
choose to be protected.
Yeah.
On the contrary, you have to choose not to be protected, which may sound slightly weird, but the way that comes about is a landlord may wish to only grant you a lease which is not protected.
Yeah.
And if he does that, he's got to follow a very precise procedure. He has to serve a absolutely prescribed notice on you. Normally, he will require you, again, it slightly depends upon timings, to provide a written statement, a statutory declaration that you have received the notice and that you agree that it will be outside the act. That has to be done. There's no room for maneuver. There's no
Mm.
discretion. Unless that is followed absolutely correctly, you will be protected by the act. But if you've gone down that process and agreed to it, then you will be outside the act for the purposes of renewal of the lease.
Fine. Absolutely understood. Great. So you would know if you were outside of the act. You would have signed
You should do.
something. There would be paperwork. It may be years
And it will be in the
previously.
lease. And it will
It,
be in the lease. The lease is not conclusive because the lease refers to you having been served and so on. And so when this happens, we will say to a client, well, let's just see the documentation. It may not be correct. The fact
yes.
it's in the lease is not enough.
Fine. That's a very good point. It's a very good point. With regards to the timings issue, and we hypothetically spoke about a 5 year lease at the outset that's renewable, and we'll say that's protected. If you say 5 years has passed and nobody's issued a notice, you carry on ad infinitum. So obviously 5 years could slip into six, seven, eight, nine. And so at any point, either party can still issue that notice. They can still begin that process to either bring the lease
Yes.
to an end or create a new agreement. And so, yeah, I think some tenants that I have dealt with in the past, they have sat back and waited, imagining that their landlord is going to just magically pop up, and they don't have to. They just don't
No,
have to. They can
no,
just sit and bide their time. So yeah, it's a crucial point for any tenants listening here that, if you want to get a new agreement, you may have to make the first move. Now, obviously,
yeah,
making moves in regards to commercial leases, etc., there's a cost involved. Um, and obviously, these can spiral out of control if you don't keep a grip on what's happening. So, a little bit of knowledge is crucial. A lot of knowledge would be a massive advantage, I think. And that's one of the things I've attempted to do, and you yourself, is just
yeah,
inform people. And hoping that this podcast itself today will give a little more of that weight to people about making sure that they don't accidentally lose their agreement or lose their rights or stay on the wrong rent. Because let's face it, the end of a lease is a break point for a rent, for a new rent to be struck for
yes,
the new term.
yes,
And obviously, if you stay on the old lease for longer than it was written down for longer than 5 years, you're on the wrong rent potentially. I mean, it may be lucky you're on the right rent,
Well, you
but
may be on the right side of it. Yeah.
you
Who
might be
knows?
on the right side of it, yeah, in which case say nothing. But
Yeah.
that can be hard to judge because we have met people who have gone many years past the end of their agreement. And then
Yes,
because and it always suggests to me, if your landlord does not approach you, the chances are they know you're on a rent that's higher than they could achieve in the open market.
absolutely.
They'd love to just keep you there because
Absolutely.
that serves them well.
And
But
I think that's a phenomenon which has been much more common since COVID.
yes,
I think the experience is in the business that rents dropped during and indeed after COVID, whereas before one generally expected every year it was going to go up,
yeah.
but not so now.
And I think it's a good point to give a bit of a heads up and a warning to people. There are a lot of commercial leases out there that have a penultimate day rent review. They have a rent review right at the end of that lease, literally
Yes.
24 hours before it ends, but that's not a renewal. If you do that rent review, you are not renewing your agreement for a new term.
Correct.
You are literally just fixing the rent for whatever
Yes.
period comes after. Yeah, and it's not a new agreement.
Yes.
And so,
I should, of course, add that once either party has sought a new, to terminate the lease or a new lease, of course, um, either party can seek the determination of an interim rent. So there is still that there. So you might apply for your new lease. In the meantime, the landlord could say, I want to apply for a new rent in the meantime,
right, yeah, because the
and vice
anticipation,
versa.
in anticipation that perhaps the agreement or the setting of a new lease could take some time, so they would like to have a rent as a benchmark almost
Well,
to
it would take some considerable time. Usually, it's
yeah.
wouldn't take
So
a
if
week.
you're not careful, you could end up fighting rent battles without getting a new lease, and
Yes.
this just adds to your costs. So, from a
Yes.
tenant's perspective, considering that most tenants are financially going to be weaker than their landlords, the property
Yes.
owning side of it, they definitely need to get advised and be well aware of all these moving
Yes.
parts because you don't want to go in fighting multiple rent battles when actually what you're really after is just a new lease and a new rent. You don't want to be fighting all the other stuff.
No. But although I would say, again, experiences that since COVID, the applications for interim rents are far rarer than they were before.
I
I think
totally agree with that. Yeah.
tenants hesitate to do it, even if they think they will get a lower rent because they might not, and they're going to incur costs.
Mm.
Um, and pub companies, for the reasons just said, may consider that actually they may actually face a reduced rent, so they're quite content with the one they've got. And
They'll just sit
why
on that.
put it at peril by applying for an interim rent?
Absolutely. And I wanted to be clear as well that in the event that you get a new lease granted and you set a new rent for that lease, it's not backdated, is it, to the last day of your original
No,
5-year lease? If your
no.
lease is carried on, yeah. So you could be paying the wrong rent for 5.5 years and then get a new lease. You've
Yes,
negotiated one. So, but you've paid an extra 6 months. So it won't be backdated
yes,
to the 5-year point. No,
correct,
absolutely.
correct.
And just I think it's worth pointing out at this moment, and this will be for another episode, but obviously the renewal of a lease and the issuing of those notices that we spoke of, section 26 and 25, those notices does trigger MRO, market rent only. So for those publicans who have rights under the PUBS code, that's an event, and you'll probably want to exploit that. Again, the timings are tight, and people need to do
Yes, I mean, there's quite a lot to be said about that, but that is correct, and that would be a reason for a tenant serving a Section 26 notice to trigger the MRO event if they want to go for an MRO.
absolutely.
And of course, again, you must get professional advice. The time limits here are incredibly tight.
Mm,
You've got a very short period of time after you've served your Section 26 notice to serve your MRO notice.
correct.
Just got to get this all right. You've got to serve it on the right people and so on. To do it without professional knowledge, I genuinely think is a very dangerous thing to do.
It's quite risky, I agree, and I have met people who have sat back and waited for responses from their landlord and lost their rights for MRO. So yeah, key warning there. Just wanting to kind of pick up on the cost issue here. So in terms of renewal ending up in a battle. I mean, obviously, you could end up in court. There could be hearings. There could be multiple things that could go wrong as you give evidence. In your experience, Stuart, most of the battles that you have seen, they have been settled without court. Yeah, on the steps, as we like to say.
I would, well, I wouldn't say even as far as that. I mean, frankly, um, we very rarely end up fighting one of these in court. It is an extremely rare event. Having said that, the procedures up to that often do. Often it will be quite a late stage that the parties will settle, normally by the pub company giving way or making an offer that the tenant can't refuse.
Yeah,
Right. Um, so the real big costs, probably 30 or 40% of the costs occur at the very final stage if it actually goes to court for a battle.
yeah.
Before that, the costs are relatively small by comparison. And as I said, and quite often these settle relatively quickly,
Yeah.
relatively.
No, well, that's a really good point. It's heartening to hear that, and I do believe that speculatively landlords issue these notices and try to oppose renewal on the grounds that they're almost testing some tenants to see how much money they've got and whether they're getting advised.
What
It's
what
leverage. Yeah.
we have found recently, a different law firm has been acting for one of the pub companies,
Mm.
and they certainly began when we were dealing with them to start putting in frightening uh, budget costs for, frightening. Well, we managed to get the courts to knock those down to something a lot more acceptable. But they're there to frighten tenants. They're there to make them think they're going to face a huge claim for
Yeah,
costs if they lose.
sure.
And one of our jobs is to try our best to make sure that ain't going to happen.
No, and I think also tenants need to be quite focused on the long-term gain because even if a renewal battle is 5, 10, 15, 20, 25,000 pounds, if they get a new lease, that's valuable, another 10 years, and also on the new rent. So they can, these
Yes.
costs, really just
Well, they
disappear.
probably get their costs as well. I mean, the probability is that if you've settled a case in this sort of early stages, either your costs can be quite small, or and will be and may well be paid by the other side. It's not unusual. I
Yeah.
mean, it's not the rule, but it's not unusual. Um, they're either going to be quite small and paid, or if they're not paid, as I said, they're going to be, in terms of a commercial deal, you're far better off getting you a new lease and its benefits than the relatively small legal costs you've had.
Yeah, I must admit,
It's
I think
commercially
from
viable.
on a point of strategy, I've seen rarely a good reason for a tenant to continue to hold over. I've seen it often as quite a false economy, especially in the post-COVID world. It's never had a good reason to do it. But that said, I think my record, at least the client with the record, was 9 years they were holding over beyond the end of
Yeah,
beyond
yeah.
the end of their agreement. Hmm.
However, I would say that one of the strategies here is, um, quite often our clients want to say, well, whether I win or lose, I'd like to stay there as long as I can.
Yes.
And the procedure is very slow.
Hmm.
An example, I mean, to give a classic, normal example would be, if you got to the point of issuing proceedings, you're unlikely to be in court within 18 months,
Yeah, that's a good point.
for the final hearing. So, and then on top of that, if you fail, you get another 3 months on top of that. So there's every reason, if a tenant says the most important thing is to have as long as I can, whatever the ultimate result, well, then we can make it very slow. And one of the ways around this is the landlord can initiate the court proceedings if they want to speed things up. Although I have to say, being involved in both types of case, both initiated by tenants and landlords, it doesn't ultimately seem to make much difference. It's still very slow.
Yes, the executive at the court level is deciding the timings, and they're very
Yeah,
slow.
yeah,
So yeah, it doesn't
very
matter
slow.
how urgent you feel you are, they're just going to slow you up anyway. And that is a really good point actually regarding the timings. I mean, and as we know, further complications can exist. We have some people that not only want to renew, but they also want to do a back-to-back assignment. And so they're renewing and they're literally transferring the pub to a new trading entity or limited company, or yeah, there's a change in partners or something
Yeah,
going on. And that can also juggling that and fitting that all together is crucial.
I think the thing is that if you're properly advised and represented, we can to an extent tailor how the thing proceeds to
Mm,
your needs.
yeah.
We can always speed up, to an extent, and we can slow down.
Mm,
Um, so, if you're eager to get your new lease, and they're not agreeing, we can make things go a bit quicker, not
sure.
much quicker, but a bit. But we can certainly drag our feet for you, and we can certainly give you longer if you need it. There are
Yeah.
ways we can do that. The pub companies know that, and that is the reason why, in my view, they settle so many of these. Because classically, they will decide, shall we say, hypothetically, in 2023, they decide they want to manage their pubs.
Mm.
By 2025, they don't.
Yeah.
Um, And so, merely the delay has led them to change their mind, and that is not unusual. But equally, they're aware in 2023 that if they do oppose renewal, they're not going to get the pub back for 18 months or 2 years, possibly. So that kind of influences their commercial decision.
Mm.
So I think the delay is a factor which pretty much entirely plays to the benefit of the tenants.
Well, I'm going to ask listeners to stay tuned now because we're going to talk about a specific example, a case, if you like, where what's happened has caused a great deal of problems all round, shall we say? But let's discuss a particular classic example that we've just happened upon. It's a shared client for you and me. We won't mention their names. We'll say John and Janet at the Dog and Duck. There you go. That's
Yeah.
fair enough. So, Stuart, take me through what happened to John and Janet.
Well, this demonstrates the interplay between the desire the dislike of pub companies and MROs to how they deal with lease renewals. So John and Janet and the Dog and Duck, way back many months ago, were offered a new lease by the unprompted
Yep.
by the pub company on the usual slightly extortionate terms to be negotiated. Not an issue. But they're a tied pub. They decided that they wanted to go MRO. So they decided to serve a Section 26 notice. Um, Obviously, we advise them that can have an effect. It can prompt an objection. It can, we don't know what's going to happen, but we put quite a long period on it. The MR, the Section 26 notice would not, in fact, I think, take effect for 8 or 9 months. So they had that anyway. And guess what? Back comes the pub company with an objection on the grounds they want to manage themselves. Now, they obviously don't. Um,
Yes.
but what they're doing is they are preserving their ability to argue that as a bargaining counter. And what they're going to do, I mean, I can write the script. What they're going to do is they're going to, in due course, come back and say, I tell you what, here are our terms for a new tied lease. If you drop the MRO, you know, free beer for life sort of thing. I mean, they do come up with some remarkably generous offers,
Mm.
in my experience, actually. So that's a classic case. Now, obviously, it causes disquiet for the tenant and uncertainty, but that is a classic procedure. They really dislike MROs because they often lose considerable amount of money on them,
Mm.
and they want to frighten the tenants back into having a tie pub. And sometimes that's a good commercial result for the tenant. Sometimes they are ending up with such a small tie on such generous terms that it's a good deal because they're paying a lower rent. But that's a classic way it's going to proceed. So the service in MRO 9 times out of 10 seems to provoke an objection to a new lease. Um, but in most cases, it leads to a settlement anyway.
Sure. And that may be, as you say, the tenant either going tie free or staying
Yeah,
tied. Obviously, using that to its leverage. But for that period, yeah, the tenant's getting a flap, an absolute flap. There's
yeah,
blind panic. We're going to be thrown out. We're going to
yeah,
lose all our investment, yada yada. And
yeah.
that does, we've dealt with people like that, and we've tried to bring them down off the shelf. I think if it's off the shelf or the top of the tree or the cliff, wherever they're standing, but they're in a bit of a panic with it.
Okay,
Absolutely.
can I just pick up a point there, Chris, you made? Because
Sure.
just by the by, um, a thing that is often overlooked by legal advisors who don't do a lot of this stuff is that where a tenant has put a lot of money into a pub, and we find very often that's the case with our clients, they have put in six-figure sums into their pubs in improvements to the pub.
Mm.
In many cases, if your lease comes to an end for whatever reason, you can seek compensation for that, which can include the difference between the value of the pub without the improvements and with the improvements. I just mention that because it's frequently overlooked.
Sure.
I'm not saying it universally applies. In very often, the improvements won't be within that, but it is absolutely worth looking at.
Yeah.
And it can be, of course, a factor for deciding you want to go because you can get a big
A
chunk
bit
of.
more money, yeah. And
Yeah,
just on this point of compensation, let's talk about that. So there is compensation, which you say is kind of discretionary. You have to apply for it. It's with regards to maybe improvements you've
That would
done,
be an
but you
example.
have
Yeah.
to argue it. And then there's statutory compensation, which
Correct.
is due under the Act, and that
Which is
which is based on your rateable value. Yeah,
precisely. And that
absolutely.
that applies in any case, certain 31G, any non-fault case, you are entitled to that once or usually twice the rateable value.
That's right. And the law as it stands is that as long as you've been in use and occupation for more than 7 years, you
Yeah.
get one times your rateable value. And if it's 14 years, you get two times, and that's it. There's nothing above two times. But just a point I'd like to make about that, if you've assigned the pub from a previous operator and have paid at least £1 for that assignment, you
Yeah.
carry forward their occupation.
Correct.
So let's
Correct.
say you've been there 5 years, they've been there 10, you assigned it from them on the 10th year, then actually it's 15 years. So you've actually tipped over that 14-year period. So,
Yes, absolutely.
crucial
I,
again for,
we had actually just very recently an example where the very experienced solicitors on the other side, I think actually innocently, but maybe not, forgot that and thought that, oh well, you haven't been there 14 years. Or, well, actually, have a look at the lease.
absolutely. I
Ah,
think I stopped someone a few years ago who was going to assign it, I think, to their brother, and they said, "Oh, well, we're not charging them." And I said, "No, you must charge at least £1 because there
yes,
must be a token here to
yes, yes,
create that continuity."
yes,
Because otherwise they would argue, yeah, there was a break in the tenancy. And
yeah,
actually, it's an interesting point because as we have met and probably understood ourselves, there have been people who've started off in their pub careers maybe as sole traders, or joint sole traders, husband and wife, on names on the agreement. And then a few years in, they've gone, right, we want to create a limited company. And sometimes the pub company has allowed a new agreement to begin under the limited company, but this has created a break point because there wasn't an assignment
yeah,
as such. So people
yes,
do need to watch out for that. If they want to keep those rights, keep those compensation rights, make sure you do it properly. Very
yes.
crucial point.
I should just say as a footnote here, it's not
Mm,
always understood that the Act is largely blind as to whether a landlord or a tenant operates through a company or as a sole trader. I mean, in terms of continuity,
yeah.
so the fact that the tenant is a single person, but he trades through a company, the Act ignores that and treats it as his business.
Yes.
I just mentioned that because
Fine.
it's
No, that's
people
absolutely
sometimes worry about that.
okay.
It treats it as the same.
No, that's very interesting. And let's just pull up on something which again little known but does come up from time to time. The landlord cannot take the pub back for their own use if they haven't owned it for more than 5 years. So as we know, there's been a number of pub companies and or other players who have bought chunks of pub estates, traded them almost like, trading cards in a school playground. But this has created an issue whereby they haven't owned this pub. Could you just talk us through that bit of the legislation?
Yeah, well, I mean, it is quite complicated. And in fact, we a few years ago fought two cases on this issue. Um, we lost the first one, but the pub company then made an incredibly generous settlement when we lodged our notice of application to appeal. The
Yeah.
second time it happened, we got permission to appeal, and they made an even more generous settlement and haven't argued it since. So, but the 5 year rule is yes, basically just that. Where it gets complicated is where you have more than one company in a group,
Yeah.
and they can sort of try and transfer that to another company because there are provisions under the Act which will treat and will give if you like, give the 5 years to a different company in the group if it's in the same group. Does
Yeah.
that make sense? Yeah.
It does make sense. Yeah, absolutely. Again, this is the other sort of shuffling of the pub company deck that goes on. It's not even that they're selling a tranche of pubs to
Yeah.
another operator. They're moving them internally amongst their corporate structure, their holding structure, and this can create a paper trail. And in sometimes the paper trail is not good enough, and the 5 year rule does apply as well. It can create these problems.
Yes.
Yeah. No, it's a very
Yes.
interesting part of it, and it's definitely one that does get overlooked. And I know we have been involved in, as you say, in a number of those cases.
It's
So,
compli I would say it's complicated, and I would say that again, if a tenant served the Section 25 notice or an objection to Section 26, it's really worth getting as lawyers to check it because there's many a slip. We discovered in one case two companies were not in the same group. Ha ha.
Yes.
Uh, and
Right.
and and classically, the pub companies will have company A as the company that's going to run its business from the pub, but company B has the freehold.
As yes.
These
Yeah.
are complicated situations, and don't take it for granted because
No.
we don't.
No, absolutely. And just to wrap up, I just wanted to end on the issue about landlords' intentions. And this is a defense mechanism for tenants can use about firm and settled intentions. Can you just give us an overview of that, the firm and settled
Yeah,
argument?
this is sort of a developed law that basically the court's position is in interpreting the act is that for a landlord to establish 31G that he intends to run his own business from it, um, it's got to show that not just he would like to or he may, the landlord's got to establish that he has a firm and settled intention to do so. Now, there isn't a specific set of facts that will establish that or not. Sometimes landlords fail on it. It's quite complicated law.
Mm,
The cases are, that there are so many different instances. But for example, I mean, to give a sort of an extreme, um, a company, if the company is the landlord, it's going to have to produce some internal contemporaneous document showing it had decided to do that. And it's also got to show it's able to do it. Because if
yes.
it ain't got the money, then it ain't going to do it. And so things like, so for example, it might be that if they put in a manager and so on, it's not going to make any money. I mean, and we could possibly establish that on, but with an accounting evidence.
Mm,
That isn't conclusive though, because the landlord's entitled to make a loss. Um,
yes. Fair enough.
it is evidential that they probably don't have that settled intention, and we're actually just looking at a case which arose from some years ago, where it looks to us as though the pub company did mislead the court, saying they intended to manage it, but in fact, that was a temporary measure before
And
they
then
put in a new tenant at a
they
much higher
let it
rate.
out. Yeah. Very,
Now,
very.
there are remedies when that happens. It ain't easy,
No, no,
and
they're very specialized, and again, nothing you could
yeah,
undertake on your own. Yeah, they're quite interesting. In
no,
fact,
no, this is high level
yeah,
arguments. Yeah,
I know there may be a few more of those coming up because as you say, people have become increasingly aware, and I think it's interesting to see larger pub companies that develop models which don't sit quite in the tenanted division, don't sit quite in the managed division, but occupy that knife
correct.
edge. And anything on a knife edge is uncomfortable, and largely you could give it a good shove and it might fall off. So
Absolutely so. I
yeah,
mean,
no,
yes. I mean, a classic example is you get say a town pub, a wet pub, where the landlord makes a decent living. I mean, he enjoys the social life, he enjoys the pub, he works hard, he's
mm,
probably family help out, and he's very happy with the way it is. A pub company comes and say, we're going to spend 150,000 on capital expenditure, and we're going to put in a manager at 50 or 60,000 a year, and you're going, ain't happening.
yeah,
That's just not real.
no, no.
Um, and
Well,
you may, in some cases, win that argument.
Well, I must admit, I think one of the most startling cases of firm and settled intention I came across wasn't a pub, it was a corner shop. And I'll just briefly give you the overview, but it should make you smile. The gentleman that ran the corner shop wanted a new lease, and the freeholder said, no, no, I want to run the shop myself. And they said, yeah, but you're going to let your son run it. It can't be for you, surely. And he said, no, 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 I'm going to run it myself. So they thought this was a Trojan horse, that the elderly freeholder was just simply wanting it back and was going to install their son, who was younger. It went to court, and the landlord lost because, as the tenant showed, he had had a retirement party 4 years previously announcing his retirement from the industry. And the court held that that was not a firm and settled intention because the age that he was, he said he looked forward to hanging up his apron and no longer trading behind the till. And
Well, yes. I mean,
that was absolutely
mind
classic.
you,
He was,
I
yeah,
should say, sort of, On the other hand, one of the leading cases on this is the bizarre case, very well known, of a shipping company that bought a restaurant.
That's right. Yes.
And said, well,
Yeah.
we're going to trade that. It's our business. And we went, what?
We're
You're a
going to do
shipping?
restaurants. We do shipping and
Yeah,
restaurants.
yeah,
Yeah.
but they succeeded because the court was persuaded that in fact they were going to install a head chef and manager who was who was going to work for them and was going to run it. And the court, yeah, okay, yeah.
Yeah.
So I mean,
That's right.
these are all very evidence specific, as we say in the trade.
They certainly are, yes, indeed. And that shipping restaurant case is bizarre but interesting for all those. But they did just have to jump some hurdles. It wasn't
Oh,
just a
they
walk.
did, yes. It
Yeah,
wasn't easy.
it wasn't a walk. And that's a very good point, I think, to end it on. We'll end it on shipping. We started with pubs, and now
Well,
we're ending
indeed.
with shipping, of which we know very little about. But thank you, Stuart, for your time. It's been terrific chatting to you about that, and I look forward to hosting a few more podcasts, and hopefully I can get you back again, and we can discuss some of the other wonderful facets of this beautiful trade that we inhabit, the pubs trade.
Be a pleasure.
No worries. Thank you, Stuart. Thanks a lot.